Let's change the point of view. Now we have dwelled into patents, and now it's the time to look into copyrights. There are benefits of and challenges with the AI-driven technologies for copyright, and we have two experienced speakers to talk about this. Firstly, Anna Vuopala, Government Councillor from the Ministry of Education and Culture. She has for a long time already participated in the discussion and relating to copyright issues both in Finland and internationally. She will be then followed by Jari Muikku, who is also very experienced in the, especially in the industry of in the creative industries. And as soon as we have heard their views, we will then move to the panel discussion. But Anna, please, the floor is yours.
Okay, thank you very much. Good afternoon from my part. Yes, I represent the Ministry of Education and Culture and not the industry per se. We have heard a lot of views from the industry, which is of course very central to AI development. I will first try to tell you about the key takeaways, because this is a favorite subject to me. Data economy, artificial intelligence, and data per se is it's very interesting to me and also to the ministry. So if I get carried away, I want you to get at least these things with you. So first of all, we're talking about AI in the data economy. That's the term now, but looking back, for example, 20 years, we have seen the development of the internet and the names of how to make business in the digital environment. I will look at that for a while. The approach for us is that artificial intelligence is definitely more of an opportunity than a threat to the copyright system. It's very important to always try to focus on the positive sides of technology and then try to kind of keep the law, of course, also intact and developing to the needs of that. The Finnish information policy was given last year, so in that we clearly state that Finland as a state wants to put all the possible resources and finances that are available to make sure that we can use the data in the data economy in an efficient way, and especially emphasizing the ethical use of data as well. I think that the approach that the ministry in Finland is also seeing, meaning the fact that AI, artificial intelligence, should definitely be used to benefit the functioning of the copyright system, really lies actually on that policy. We want the data to be used in a way that really supports the copyright system itself. My presentation won't go into how AI creations can be protected by copyright. This is not something that we see to be something of the most important questions, so to speak. But it's of course natural that when we talk about inventions, that patenting comes up. But I have a colleague from the Digital Media Finland who will speak more about these issues with regard to AI creations and copyright as a means of protection. What I want to say is that when we try to use the AI for the benefit of the copyright system, we need to understand that the languages are different for AI developers and technology in general, and for the right holders and copyright. And I think that's one of the obstacles that we've had so far. We have not been able to kind of, in these fields of expertise, to actually meet in a way that is meaningful. So I wanted to go back to this kind of historical jump back to 20 years in time. It's important to me because that's when I started out with copyright issues myself. I was started out to make a thesis actually in around 1999 on the internet treaties, and in particular articles 11 and 12 on TPMs and rights management information. I don't know if any of you remember those anymore, but that was the way that we thought at that time how to make business in copyright and IP. That was the idea that once we apply TPMs, once we have information about the rights, we can actually make money. Well, we knew that that was not then quite soon. We knew that the markets are not able to transform into the digital age this quickly, so we had our fair share of problems. I was actually admitted to the Ministry of Education and Culture because of that thesis I made, where I compared the systems of the EU implementation of those internet treaties with the US implementation of those treaties, and also with respect of TPMs in particular. So that's why I have been actually all of my career I'm trying to always encompass the best of the technologies that are available, at the same time remembering that rights holders are not necessarily able to transform their markets as quickly as the technology would allow. But it has been really something of a struggle. But so the kind of the path goes to the 2001 Information Society Directive that was implementing these internet treaties. And the basic foundation of copyright is, yes, it is relevant and is in force in the digital economy. And then we go further on of mass use of works, actually, and mass digitization, making the name of the information society actually a knowledge economy. And you realize that works can be also seen as knowledge, and knowledge can be seen as bits of data. And that was something of a struggle as well. But I want to read out something that was included in the Information Society Directive in the recital 55. It says that technological development will facilitate the distribution of works, notably on networks, and this will entail the need for right holders to identify better the work or other subject matter, the author or any other right holder, and provide information about the terms and conditions of use of the work or other subject matter in order to render it easier to manage these rights attached to them. Rights holders should also be encouraged to use markings indicating, in addition to the above, inter alia the authorization when putting on works on these networks. So it really stated quite clearly, even though we don't have a registration system in copyright like we have in the other industrial rights, there was something that said that the right holders should actually put the information over there, and they should actually try to make the best of it. And this has not happened. And we knew that, or not in a broad scale, of course. We have right holders putting some information on the works called metadata, but it's not really it's not in a uniform way, and it's not very, very clear. In 2009, we went to the knowledge economy. I already touched upon that. One of the major problems there was, of course, a market that was not very developed yet, but also the IP clearance of those rights that you needed for mass digitization and putting the vast collections of works in libraries, for example, available to researchers. And that was a very big problem. I was actually, at that time, working for the Commission to try to actually do something about this orphan works problem. Orphan works means works that cannot be found. You can't find the author, you can't find the right holder, and therefore the licensing is very difficult. And that was then we tried to find out a solution by introducing an orphan works directive system where you try to step by step kind of give a term to works that are not, you cannot find the right holders to. They are orphan works, and then people can use those works but not have to license them. It's a little complicated. It should be better, that all works can be licensed, and we had in Finland and in the Nordic countries developed an extended collective licensing for that. The funny yellow part is when internet became funny, it started to become nice for the users. It started to come also nice for the right holders because some legal offers were there. We started to see the platforms developing, the speed, 4G was already there, allowing also movies to move swiftly. So we had a kind of a short time when we had found the business model and everything seemed to be fine. But now we are again approaching, some of you know the DSM directive at the moment, it's in a critical phase. We try to find some solutions on how to establish responsibility for platforms to license works, and that's a very important thing. Of course, when you use works, you have to license works. It's nowhere free. But the problem is that how to do that and how to formulate those rights. We believe that instead of asking for big operators or putting somehow new twist or expanding the copyright system, we would actually go back to these internet treaties, go back to where we already have this initial claim that please put your rights and your data into these works, and then kind of through that help the system work properly. Meaning, for example, blockchain technology needs data on who owns the works and who are the right holders. AI-enabled technology needs open access to repositories of works. And how to make that? I mean, we probably have to do it in a way that is good for everyone. So we are embarking on this project at this in the EU presidency. We are trying to establish in one of the conferences coming up in the fall. We have a title on developing the copyright infrastructure, and that would be particularly focusing on improvement and verifying of metadata of works and right holders. So going back to the picture is that I think that after 20 years we should be able to really see what the AI could do for copyright. We could actually make copyright much more automated. We could actually get companies and other commercial users to see copyright clearance as a routine and not really a very cumbersome task, it seems like to be. So, with the help of AI, really offering licensing wherever it's possible. I think at the moment, the discussion has always been a little bit like the ones who are developing new technologies need copyright licensees and who comes to who first, that the technology people should come to copyright people or vice versa. I think even within the content industry itself, AI could be providing really, really efficient help to license works for the industry. So this is something that I think all of the different fields of copyright should take back and hopefully develop on, and that's what we are here for. I've really enjoyed the last speaker, for example, how to write an AI invention application, because that could be a good thing for some of the right holders who already work on these issues. So since copyright is a term, or copyright has a term of 70 years plus the life of the creator, it means that really we need to have sustainable solutions. We need to have something that really makes the management of the work run all through the life cycle of the term. So that's very important, and that's why we also feel that really need to look at this in a firm and robust way, and not just kind of allow something to happen only here and there. But we are not saying that this is something that you have to make an international agreement on. It's definitely not something to do. We should more focus on this is the quote that you can see over there. Oh, sorry. It's from the WIPO website, where they interview this expert on AI, said that we need a strong venture capital ecosystem to drive the technologies to the right application areas and relentlessly try to find the user needs to improve the technology further. So I think this is something that we should also understand for copyright. Mr. Francis Gurry, he already mentioned that Finland and we have been developing and investing in metadata processes or projects already. So we have an application already actually opened yesterday, focusing on metadata issues. So I hope that some of you might be interested in that, to try to apply for a grant. But we have made 2 studies on metadata for music and also for pictures and for websites. So try to kind of improve the way the metadata is put to the work from creation to end. And hopefully we will also later on see other member states of the EU interested in this and finance it through EU Horizon or even with WIPO-led projects. For the end, I would like to tell you just very shortly about the Concertify, and that's a project that is developed by a company owned by the CMO Teosto. So the music CMO in Finland has been very proactive in the digital licensing business with regard to blockchain and AI and so forth. And I think that this is it's a good start to try to simplify licensing processes. This is in particular about the live music, but there are similar types of platforms that can be developed for different sorts of works. So basically, the end of my presentation, the final key is to try to seize the benefits of the opportunity provided by AI. That's my main takeaway for this presentation. Thank you very much.
Thank you, Anna, for the very positive tone in your presentation and an ability to speak quickly, but clearly is an asset. You really have it.
Okay.
And in case there are any questions from the audience, please raise your hand. If not, we move on, and Jari Muikku, a consultant from a well-known Finnish firm, Digital Media Finland, will offer his view on the... Oh, there's one question. Sorry, Anna, could you please raise up, and there's one question.
Yeah, thank you. It's Willis Deutler again. I have a short question, and that is, in the copyright context, do you have any considerations with regard to validity or invalidity? Because, as you know, there's more and more content, and content is alike, and it becomes fuzzy. Is it a valid claim or not? So I would be interested in your view.
Well, yes. Actually, what I omitted to say in the beginning is that my favorite AI application at the moment is the content recognition system. But it doesn't sound that good normally. Now we know what it's used for, and it's not very efficient. But it could be very efficient if we have a trusted partner or a trusted system behind that to verify, the ownership for each, let's say, version or so to speak. So we are not deciding at that time when we use it whether somebody owns it, but there is a verification of who owns it at that time. I think that's the only way to do it, because we can then fight in court later on about the fact that we have something to go forward with, so that's more important.
Thank you for your question. Sorry, I missed it firstly. Are there any other questions from the audience? If not, we give the floor to Jari Muikku. Please, Jari.
Okay, thank you. Good afternoon, everybody. So my name is Jari Muikku. I'm a consultant and CEO of a company called Digital Media Finland. We are a consulting company concentrated on media, creative industries, and ICT. And it's my pleasure to talk briefly about the relation between artificial intelligence and creative work. So there are a lot of issues concerning this area, but I try to put certain issues on table. So the relationship between creative work, especially artistic creative work, and machines is nothing new. It has a long history. And I was recently visiting Berlin, and as a big fan of the TV series Babylon Berlin, I participated in a bus tour which covered the wild 20s in Berlin. And a certain photo came to my mind, which I used to have hanging on my study wall for a long time. So this is something which happened 99 years ago in Berlin. And this photo is, of course, from the first Universal Dada Fair, which took place in 1920 in Berlin. And this poster says that the art is dead, long live the new machine art. And Tatlin refers to Russian artist Vladimir Tatlin, a constructivist and avant-garde artist. So this has been an issue for a long time. So one could ask, so what's new? Since computers and various kinds of programs have been used as a part of artist's creative work already for a long time. Another example, if we come back from 99 years to 1960s to Finland, some of you may remember a Finnish tango song called Kesä muistatko sen, which used to be a big hit. It was recorded by Esko Rahkonen. And the author of this work was an IBM computer. It was done as a part of the study project in Turku University. And this kind of combined together all the typical features of Toivo Kärki's composing styles. So, and this was statistical analysis, and back then already there was a big debate whether a machine could be credited as a creative author. Well, the new features which we have now with artificial intelligence is that we have increased level of intelligence in use and wider scale and more nuances in usage. So I try to kind of concentrate the main points here about the scale, how the usage of artificial intelligence can be seen in creative work. And this is not a kind of, these are not absolute categories, but more like a kind of a seamless scale. On the left-hand side, you can see that the artificial intelligence can be used as a tool, functional tool, so that this doesn't have any other role. And on the far right-hand side, you can think artificial intelligence as a creator, a substitution for a human creator. So and whether it's going to take place or not, I will come back to that in a moment. I think the most interesting area regarding creative work, especially artist creative work, is the middle section, where the artificial intelligence can be seen an enhancement or enrichment or augmentation of human ability to create something new, have a new kind of way of looking at the world. And especially how artificial intelligence treats the material, the inspirations very differently than a human being. If you put on top that one categorization of artificial intelligence, this is, by the way, used, for example, in the US government, is that, well, starting from the left-hand side, you have the reactive machines, then limited memory, and then when you come to the theory of mind refers to a situation where artificial intelligence can understand human emotions, motivations, and read the surroundings in that way. And especially when we move to self-awareness, of course, we are in the realm of science fiction, more or less. But on the other hand, this is not kind of compatible with this the other model in a way, because, for example, if we talk about the reactive machines, we have had, for example, for some time now, artificial intelligence solutions which, for example, write short news, weather forecasts, and so forth, even though it looks like it's a human being who has written this sports news, what happened in the ice hockey match yesterday. So, and this self-awareness of this singularity state, of course, is something which is way ahead, and some, of course, doubt if that ever will take place and whether it should take place. Well, how this artificial intelligence is used already, and where it could be used. So I take a few practical examples from the world of music, which I have a background in music business. So, for example, if you take Hollywood movie productions, you probably know that these blockbuster films, studios usually do several versions of that and have test audiences. And with artificial intelligence, you can fine-tune the effects, that is to say, what kind of emotion you want to raise in the audience. For example, this means that if you have a certain scene, and you want that the audience will feel, let's say, maximum amount of compassion towards a certain character, you can use audience data. Of course, you need audience data reactions to see that what human mind cannot really perceive is that if you do something for the music, it will kind of raise the effect you want to have. It's the same thing in the post-production with the colors. You define them a little bit differently so that you kind of have a more this kind of reaction you really want to have. So it's a functional tool, something which a human mind cannot really read, but where artificial intelligence can help to reach the certain goals. Then you have this category which has been already discussed here, is that when you create something new based on some style. For example, in music, there was a kind of couple of years ago, there's a project where some new Beatles songs were written, a little bit similar way like I described the tango 50 years ago, but of course with the much more refined tools. And then when you have this kind of situation, there are a lot of copyright issues coming up from that. If you use certain material, like let's say creating a Beatles songs by using the whole Beatles catalog, the recorded catalog, so there are a lot of licensing issues, which can be kind of compared to the text and data mining issues, citing, so forth, and who's responsible for licensing certain rights, what should be licensed, who should license, and especially when you're talking about large quantities of works. For example, you want to have all musical works available in the world. But there's always also a kind of pitfall in this kind of thinking that if artists want to create something new using AI, it might be that he or she abandons the usual categories or the silos, so to say, but wants to create something new with AI by combining music, literature, visual art, and you have a huge amount of works. How is that going to be treated copyright-wise? So there are a lot of issues like that. Catalog music, if you're not familiar with the term, this is kind of functional music. If you look what a TV series, a TV program, it might say that when there's a music credits, there's only a company name. They say it's a very functional music, which is one of trade where the composer is not mentioned, but it's produced by a company. And in a way, it's used in that kind of situations where you, let's say, you have this kind of day, you have a picture from the Mannerheimintie and want to create a certain snowy feeling. You look at the catalog description, this kind of music, I buy this piece. Well, AI can kind of substitute the composer as a whole in these kind of situations. You don't need a kind of single person. You don't have to pay salary for a certain composer to write music. Already now you can do to a certain extent catalog music by using an AI. Well, this has at least two dimensions, this issue. So how the AI is used in creative work and what are the consequences. But of course, there's a lot of business consequences as well. If you look, this is an older picture, a British picture about the music industry. This is very kind of a pre-streaming service time. But music business is notoriously complex business, especially compared with the economic value it actually carries. So, but there are a lot of different kind of relations, both concerning copyrights, neighboring rights, and different players which have different kind of contracts. And, well, if you start using artificial intelligence in larger scale, you might end up in a situation where the effects are very large. It might even cover the whole picture, if you want to put it that way. It affects business models, contracts, revenue shares, and so forth. So this issue about whether artificial intelligence can be considered to be a creator or whether artificial intelligence can have copyright. So but if artificial intelligence is considered to be at least a co-creator, you can list a huge amount of different kinds of issues and questions where I don't have the answers, and I think there are no person who can answer all these questions. So first of all comes to mind, what is the legal and contractual status of an artificial intelligence as a creator? And if you use in a creative work patented artificial intelligence, solutions, what happens then, and who is entitled to artificial intelligence copyright revenues? Is the original developer, patent owner, the solution's further developer, user, and on what basis? So a lot of open questions if this presumption that the artificial intelligence can be considered to be a creator. Furthermore, with business issues, with whom are the contracts made with, according to which business models, and who is responsible for the data or body of works used in creative work, as I pointed out earlier. Also that when these works are created, quite many artistic works can be further exploited in different ways. Like, for example, if artificial intelligence composes a certain piece of music, then it can be synchronized to TV commercials, films, and so forth. Who's taking care of that? Who's entitled to the income, and what basis, and so forth. And especially so how the current collective management system adapt to this situation in cases where, potential cases where artificial intelligence should be considered to be the creator. So you can go on with the list and add up a lot of more into this. So a lot of questions, no answers yet, I think. So to kind of conclude my brief presentation is a few key takeaways. So that using computers is not new in creative work, but increasing amount of intelligence is a new feature, opening up new possibilities, and perhaps some threats as well from the point of view of an individual artist. Artificial intelligence can have various kinds of roles in creative work, from really kind of purely functional tool up to a kind of individual creator. But this individual creator is still more or less science fiction in many cases. However, the artificial intelligence use will bring along many complex questions regarding the current copyright-related laws, not only the copyright law only, but which are related into that, and especially business practices, because it's quite probable that the usage will kind of spread around and take many forms and different levels. Thank you.